In the United States of America, the way crime is investigated has come a long way, but the road to modern forensic investigation has been paved with tragic miscarriages of justice. The United States justice system is built on the premise that a person is innocent until proven guilty. In a court of law, the jury is asked if they find a person guilty beyond a reasonable doubt. The idea of reasonable doubt has been transformed by the technologies of forensic investigation because techniques such as DNA analysis offer certainty to the degree of 99.99%. All areas of forensic investigation are changing because of new technologies like 3D printing. The issues arise when the policies of the United States justice system collide with forensic investigation. Like all areas of technology, the technologies and techniques used to investigate crime are advancing faster than ever. But in learning about these technologies, I began to narrow in on one question. Is the United States justice system equipped to utilize the advances in forensic investigation? Technology is becoming more and more prevalent in the many branches of forensic investigation, which include odontology, digital and media science, pathology and biology, physical anthropology, and toxicology. Law-abiding citizens rely on the criminal justice system to catch criminals, and forensic technology is becoming an increasingly effective and sophisticated way to catch criminals and prosecute crimes. Forensic technology also plays a role in society when it is used to exonerate innocent persons who are wrongfully accused. Before the advent of modern DNA analysis, forensic techniques that were widely used included forensic serology, which is, for example, ABO blood typing, microscopic hair analysis, and bite mark examination. Many of these cases have been reopened and re-examined using modern forensic science. A total of 136 people previously convicted using these techniques have been exonerated. According to the article, Wrongful Convictions and DNA Exonerations, Understanding the Role of Forensic Science, written by Gerald M. Laporte and presented in the National Institute of Justice Journal, unlike any other scientific discovery, advances in DNA technology have improved how we investigate cases and interpret forensic evidence. The idea that innocent people can be found guilty has gained more awareness. However, this article did go into the fact that erroneous convictions, like most catastrophic mistakes in the criminal justice system, are rarely caused by a single identifiable act or weakness. To further illustrate this point, I want to first tell you the story of Ed Johnson. In 1906, a young African-American man named Ed Johnson was murdered by a lynch mob in his hometown of Chattanooga, Tennessee. He had been sentenced to death for the rape of Nevada Taylor, but Justice John Marshall Harlan of the United States Supreme Court had issued a stay of execution. To prevent delay or avoidance of execution, a mob broke into the jail where Johnson was held and lynched him. Johnson was convicted using eyewitness testimony given by a person who was not present at the crime. According to the article, A Supreme Case of Contempt, a tragic legal saga paved the way for civil rights protections and federal habeas actions, written by Mark Curden in the ABA Journal. A petition for a writ of habeas corpus was filed with the United States Circuit Court of Knoxville, arguing that Johnson's trial deprived him of rights granted by the U.S. Constitution. But would Ed Johnson have benefited from modern forensic science when he was the victim of a morally corrupt system that convicted him even before he had the opportunity to prove his innocence? In order for the United States justice system to fully benefit from the advances in forensic technology, crimes must be investigated by persons who are committed to investigating crimes with honesty, morality, and without prejudice towards any person because of race, religion, creed, or any other factor. According to the article Constitutional Regulation of Forensic Evidence by B.L. Garrett, post-conviction is a far more difficult time to bring up issues with forensic evidence since a retrial relies heavily on showing a breach of constitutional rights. Therefore, it is pertinent that persons involved in forensic science hold themselves to the highest ethical standards. The consequences of a lack of ethics in forensic investigation, where there is official misconduct, are dire. There were at least 16 cases from 1980 to 1991 involving forensic charlatans, all of whom were later terminated. Sadly, the testing results in some of those cases would have exculpated the exoneree. Interestingly, faulty forensic science is rarely the only reason for a wrongful conviction. In fact, there is a relationship when forensic science is cited as a contributing factor along with other contributing factors, including inadequate legal defense, perjury or false accusation, false confession, official misconduct, or mistaken witness identification. The most significant number of wrongful convictions in which forensic science is considered a contributing factor is attributed to eyewitness misidentification and official misconduct. So clearly, even 100 years later, the same issues that plagued Ed Johnson and caused his untimely death continue to be an issue today, even with all of the advances made in forensic investigation. This brings us to our next issue. How can we guarantee the constitutional right to proper counsel when most lawyers are not trained in forensic science? In the Constitutional Regulation of Forensic Evidence, Garrett argues that it is no longer sufficient to rely on the expertise of the prosecutor when forensic evidence is presented. The defense needs to familiarize themselves with the current technology and information regarding forensic evidence in order to provide better legal services and better prevent wrongful convictions. According to this source, lawyers should be expected to advise clients when the need for expert scientific and technical assistance in a case in relation to forensic evidence is needed. There are parallels that can be drawn between the findings of the United States justice system and the United Kingdom justice system when it relates to forensic science. According to an article, A Review of Quality Procedures in the UK Forensic Sciences, What Can the Field of Digital Forensics Learn? There is an increasing scrutiny of forensic data in the investigation of crime and the current trends and expectation as it relates to the various branches of forensic science. One finding in the United Kingdom is that due to high-profile cases where the forensic evidence is rebutted and the case is dismissed, some branches of forensic investigation are having to alter policies to ensure the evidence presented in court is sound and will not lead to a miscarriage of justice. Additionally, the UK's publicly funded services are under scrutiny, and therefore, any new technology needs to be able to produce results that can justify the cost. These issues provoke another question. Since it takes longer for a legal system to implement the use of forensic technology due to the policy and financial constraints, does the criminal element benefit more from technological advances than the legal system? According to the article, The Next Generation of Crime Tools and Challenges, 3D Printing, from the National Institute of Justice Journal, issue number 279, 3D printers can be used to do more efficient facial reconstruction, make copies of evidence that would otherwise deteriorate, or recreate evidence so it can be presented to a jury in a less gruesome manner. But because 3D printers are becoming cheaper and more readily available, they can also be used to commit crime, therefore making it a technological double-edged sword. More research has to be done regarding the use of 3D printing technology in the investigation of crime and investigating 3D printing as a part of a crime. For example, there is little research on whether forensic scientists could make a conclusive statement about the origin of a 3D printed object. In the article, Digital Image Fraudulence, A Curse to Forensic Odontology, from the Journal of Forensic Dental Science, it is discussed some of the issues surrounding digital imaging. Digital imaging is currently the preferred method of storing odontological forensic evidence. But there are many ways this digital evidence can be tampered with. The article points out various types of evidence tampering and ways such tampering can be combated. They explain some of the types of forgery, like retouching, image splicing, and copy move attack. The ways to combat these forgeries include error level analysis, which is an algorithm that detects foreign objects injected into the original image by analyzing quantization and blocks of pixels across the image. Technology continues to move forward, it will only become more and more complex. This increasing complexity will require the policies of the United States justice system to adjust so that it can take advantage of these advancements. The future of forensic investigation is moving more and more away from the physical realm and into the digital realm. This is especially true because of the emergence of digital crime. The future of forensic investigation is all about crime in the cyber arena. And cybercrime is the future of forensic investigation. Because it is such a new area, it is not placed under the same scrutiny as other areas of forensic investigation. This is not necessarily a good thing because it is the scrutiny which pushes the discipline to continue to raise its standards to ensure that all of the information and evidence presented is accurate.